प्रिय साथियों, good evening friends. I am Dr. G.K. Goswami and I am thankful for your cooperation to watch our live YouTube for various topics. Today it is our 30th live session and we shall be discussing various points on digital data protection and relevant judgments not only in India but various other jurisdictions like US, UK and many more such countries. So let's begin, friends. The judgment on digital technology and cybercrime, a global perspective. So, what is the significance of a judgment? Everybody knows this is a very common thing that judgment is broadly interpretation of laws. Many times we have seen that the same law has been interpreted differently by different courts at different point of time. Then it is embodiment of law into practice. So, judgment is a living document where law gets implemented and justice is delivered, right? So it is basically a live law. Then it fosters public trust because the outcome of judiciary is the judgment. And in common law countries like India, UK, US, the judgment issued by the Supreme Court or the Superior Court, they are binding on the lower court. So that is called precedent. And India and many more, as I told, they follow the precedent process. Ultimately, the judgment is reflection of establishing rule of law. That means the justice is delivered as per the rules and laws of the land. So, I have selected few areas in the field of data protection, and if there is a breach in data protection, there may be two remedies. One may be civil remedy, that means some compensation to the victim, or if it amount to crime, then it may also attract cybercrime investigation and other activities like registering the case by lodging FIR and all. So consent. Consent is the major issue in data protection. I think if I take the case of Puttaswamy, although we shall be discussing this case in the consent section in detail in Indian context. So Puttaswamy versus Union of India in 2017, India became the first country where right to privacy was declared as fundamental right under Article 21 of Indian Constitution of 1950. So consent, the issues mainly remains one, its validity, whether consent is valid or not, whether the person whose consent is sought, whether he was competent, and competency to consent are twofold. One is the age. The person who is giving consent must be major. Major means most of the countries it is 18 years. And then second is the mental state. When the consent is given, he should be in the sound state of mind. Then comes the consent should be free and informed. Free means without any encumbrance, without any fear or favor. So these are certain ingredients to consider that consent was genuine. Then consent has two implications. One is implicit and another is explicit. Then precedence for lower court. These judgments, I will refer the judgments also. Children's or vulnerable population consent, that is another area of you can say contest or conflict, that whether children or any vulnerable group, those who are not able to take proper consent, though they may be major, they may be sound, but their awareness, their knowledge, their acumen is not enough to take the righteous decision for giving or not to give consent. If I see the case related to the consent and data processing, Google Spain versus AEPD, where consent and right to be forgotten was discussed. Then this another important case which needs attention, and we will be discussing this case in little more detail. Facebook Cambridge Analytica scandal of US and UK. In fact, means millions of data of the Facebook users was misused for influencing the voters. So just imagine that our data, we are circulating it on various platforms on social media or other domain, but that may be manipulated for various purposes, and we may not be knowing. So that is again the domain of consent. Then another important area or the case is Naidu versus Discovery Life. It is of South Africa case where unlawful sharing of medical records was discussed. So these are certain important points. Then cross-border data transfer. Cross-border data transfer is also very important both in DPDP, GDPR or any other data protection legal framework. The issue in these matters are legality of transferring personal data across different jurisdictions, especially where data protection standards varies. Then disputed area may be adequacy of protection in the recipient country. Then violation of regional laws like GDPR, DPDP Act and many more. Then cases are SRAMS, case 1 and case 2 of European Union, where invalidates safe harbor and privacy shield agreement. You must be remember the doctrine of safe harbor. I have discussed in my short video. Safe harbor is a protection given to the data fiduciary. Those who abide with the law, they do not participate or become accomplice to the law violator or data breacher. So if the data fiduciary is law abiding and following to take down such objectionable data on their platform, then they are not under any liability of punishment, fine or whatever. So that is called safe harbor clause. In Indian law, it is in IT section 79 and was added by amendment 2008, if you remember. Then another case was Max Scammer versus Facebook Ireland, lack of legal safeguard in US intelligence access. So these are important case of cross-border transfer of the data. Then comes data breach and cybersecurity failure. You know, most of the people, and my dear friends, if you see by your own standards, many of us, I have spoken to multiple businessmen, even big MNCs also during different discussions, different forums. Many times the technocrat, they feel that right to privacy and all these things are legal domain. So how technology is concerned? But let me tell you very clearly that nowadays, and if you see especially Article 25 of GDPR to 2018 of EU, it is categorically mentioned that legality of design, privacy by design. These are the two important concepts everybody should know. And now, it is not only service where right to privacy is limited, it is the product also. So, if in any such circumstances the liability falls on the service provider. He will shift it to the product supplier. He will say it is not my fault, it is the fault of the machine, equipment. So now the privacy domain, data protection domain, it has very wide ramification. And if I say in single word that probably data protection is going to rule at least a decade by the time it gets properly settled. And most of us are completely unaware. How many of us are really knowing what is data audit, which I generally say in my terminology, data diagnostics. So data diagnostics is the new norm and we have to adopt it. And when there is any kind of fear of loss, there is insurance always. Why we go for health insurance? Why we will go for crop insurance? Because there are chances of damage, chances of losses. So to meet out those losses, insurance is one alternative. Likewise, digital insurance is going to rule the next time, maybe decade or further. So having said that, in data breaches, the dispute are generally delayed breach notification. In general, the principle in data protection legal framework is reporting in 72 hours. Somewhere it is 36 hours also. So they generally delay because who breached the or who is liable for the breach, liability falls on the fiduciary. And fiduciary is made responsible, or it is the duty of the fiduciary to inform or to report the breach. So he many times may not feel happy to report. So that is why delayed breach notification are the disputed area. He may say that I could not notice this breach. That is why it was delayed. So there are some gray areas. Then comes the negligence in cybersecurity measures. The many times, and I think most of the times nowadays, many companies are not even aware that how much their cyber system in their company or in their premise is secured. They totally depend on their own team. And who is going to accept that my system is challenged or my system has some cyber security issues? That is why third party audit is always recommended. And I think every government are focusing the third party cyber audit. And my dear friends, those who are watching this must consider that don't blindly believe what is being advised to you by your local team. Always go for third party digital audit by the experts. Now the case, if we look, Equifax data breach litigation in US, and the fine was to the tune of 700 million for settlement of exposing millions of records. 700 millions US dollar. Another case is Information Regulator versus Department of Justice, South Africa. In this, the probe is ongoing. This is very recent case, although not very recent, but still the investigation is going on for the ransom breach. Then another important key disputed area is surveillance by state, or you can say state intrusion. Generally, state says that we are doing in the national security for larger interests and so on and so forth. But individual says that why you are intervening in our privacy. So this conflict between private right and public right or national security, these are the real challenge, and that is why this key dispute. And generally, mass surveillance by the government many times, then interception without warrant, facial recognition technologies. Facial recognition technology, let me tell you very clearly that it is a proven fact that even due to AI, the facial recognition technologies have done very wrong identification because of the defective data which actually was used for training the AI tool, right? You understand, I hope, that why AI generative or AI related tools are not fit for forensic acceptance in the court. The reason is very simple, that the algorithm which are being used in machine learning and others, until unless they are being made so simple that even a judge, prosecutor, defense lawyer, they understand like in a layman language. This complex algorithm is not going to be accepted in court of law, because expert, the third condition is that you have to submit the underlying document, and underlying document must be very clear to reach out that how you reach to that conclusion. But in algorithm there are so many complexities, probably it may take little more time the AI generated forensic reports to accept in the court of law. Then metadata retention, how long the metadata should be retained, that is another disputed area. There are various cases, I have selected very few. Carpenter versus US, Supreme Court, cell phone location tracking, that was area of dispute. Liberty versus UK, mass surveillance under United Kingdoms. Then Justice Alliance versus Ministry of Safety in South Africa. Another point is employee monitoring. Many times we monitor employee for various reasons, their photographs and all. That is another area, one may say that it is the violation of our privacy right. And the issue under this dispute is whether employee surveillance violate employees' privacy rights. The disputed areas, covert monitoring. Sometimes the person may not be knowing that I am under surveillance. Many times you see on the wall that written that you are under surveillance, be aware, be cautious and all. So whether that is legitimate or not, one question, and especially for the workers, they are not criminals. How can you do that? That is a disputed area. Then CCTV in private space. Many times it is being reported for various, you can say, misuse of those recordings. Email or keystroke tracking. Cases are various GDPR enforcement actions, then Barbilescu versus Romania and all. Basically, all these cases which are more relevant, we will be discussing in little detail, so I am not taking much of your time, because time is precious, I know this very well. And another key dispute area is right to be forgotten, or it is also called right to erase. Whether an individual can request deletion of personal data from search engine or database, and how easy it is. Even if you write, how long it takes. Say it takes maybe a week, maybe or 2 weeks. By then your reputation, loss to your reputation, your mental agony may be multifold. So that these are the area how long. So although it is said that in 72 hours it should be taken down, but whether it is feasible or it is in practice it is being done. Conflict with freedom of expression or journalistic interest. Journalist generally has very, they get lot of spy information, and there are various methods the journalists are using to collect information. So sometimes they are also conflicting with right to privacy of the individual. So right of journalist versus right to privacy has some conflict. The case may be cited like Google Spain versus APD. This is landmark case of granting right to be forgotten, and other cases also in India after this Puttaswamy and all. Then platform liability and safe harbor provisions. I have already mentioned about safe harbor. So the issues here are extent to which internet intermediary are liable for breach of the data. Then disputed areas are whether platforms conducted due diligence. Due diligence is also difficult to define many a times, because there are so many platforms, so many search engines, so many things. So both parties have their own, so there is no set rule actually to say that the due diligence has been taken. So this is a gray area. Then whether takedown mechanism exists in particular jurisdiction. Real-time monitoring versus freedom of speech, these are another area. If you see the case in India, Shreya Singhal in 2014, very popular case, where section 66A of IT Act 2000 was struck down by Honorable Supreme Court of India. Then Gonzalez versus Google in United States, where section 230 of Protection Act was challenged. Then there are certain cases in United Kingdom, Online Safety Bill and IT Rule 2021 in India. The important area of dispute in data protection is automated decision making and AI. That is what I was just telling, that this is another area of dispute. How you rely? There are two areas which are contradictory, or number one, the data, the quality of data which is used for training the machine, because it actually by hit and trial it gets learned. Like for a child, you say that this is apple, and when he or she look it at, it gets registered into the mind, and then it is called training. Likewise, you register or you get them learn, right? So that is how the system get training, machine learning, right? So the data actually, suppose a trainer is wrong or the data is wrong, then the entire proceed will be wrong. That is the very important point. Don't think that always. AI is a very powerful tool, but it is a good servant but maybe bad master. We have to think about that. Then the issue here is whether algorithm used for credit scoring, policing, parole decision, infringe policy, employment lead to discrimination. There are reported cases where based on AI data, there was discrimination in identification of the human face, and it led to wrongful conviction as well. So don't believe that AI always is foolproof. You have to be very cautious always. Disputed areas are lack of transparency or explainability in automated decision making. Basically AI is what? It is a automated decision making. And how those automated programming is being done, what is the background of that automated decision making process, that is not so easy to explain or to understand by a common man like judges or the decision maker in a disputed matter. So this is again a great area. Then right to human review under GDPR. The cases if you see in European Union, Lopez Rivalda versus Spain, where covert CCTV surveillance at workplace was challenged. Then JA versus Uber in Netherlands, use of algorithm termination. Then emerging litigation in United States and United Kingdom on AI bias. AI bias, that is what I was telling, that algorithm is important, one. Then data on which your system is get trained is another point. So these are two important areas where you have to work upon. Then misinformation, disinformation, and cyber harassment. This is another disputed area. The key issues are liability of platform and individual for enabling or committing cyberbullying, revenge porn, fake news, etc. The disputed area, as I mentioned, modernization standards, digital evidence, jurisdictional conflict. The case, if you refer, Twitter versus Moitra in India, accountability for fake news. This is again very important point, that suppose somebody is spreading fake news. It may be rumor also. So what will be their liability? As I said, that there is a conflict between privacy right and media right. So you have to have a balance. That's most important part. Then children privacy and digital platforms. Children privacy, as I mentioned, that lot of pornography, lot of other misuse of the children, and areas are age verification practices, then targeted ads and content, parental consent and transparency to broadcast that material. Case may be FTC versus TikTok. You must be aware about TikTok in the United States. Violation of Children Online Privacy Act, COPA, UK ICOC, Informant of Age Appropriation Design Code. So this I have given a kind of comparative matrix. Generally I do in my presentations. So here in one slide you can see that United States key area of conflict are surveillance, data breach, platform, and in EU consent, AI, in India surveillance. Although these are not very compartmentalized, they are fluid. Say the surveillance is a problem, maybe in India, everywhere it is. So this is just which are more prevalent in those countries. That is what this table has explained. Now let us see judgments in little more detail. This, as I mentioned earlier, I will give you little more detail of Puttaswamy case. I think again that in India, right to privacy was declared fundamental right by this important judgment. And let me tell you first, in the beginning itself, earlier also I have told that the Justice Puttaswamy versus Union of India was single case, but it derived two judgments. One is called right to privacy judgment of 2017 and another in 2018, it is called Aadhaar case. But the writ petition was same. Here there were 9 judge bench and the CJI was Justice Jagdish Singh Kehar, JS Kehar. Issue was whether the right to privacy is a fundamental right. Although there are so many issues, particularly in Aadhaar and many others, DNA and so on and so forth, Supreme Court held that right to privacy is integral part of right to life under Article 21 of Indian Constitution. It impacted, let me tell you a very interesting thing, that in my opinion, that not only in India, but GDPR in 2018 was also most critical and most important contribution in developing or establishing DNA protection legal framework, GDPR 2018. Although we will talk sometime that how the data protection legal regime was initiated. If I go back in 1970, first time in Hesse. Hesse is the city in Germany. So Hesse Data Protection Act was promulgated in 1970. That was the first or historic event. And afterwards in European Union, in Germany, in UK, in Scotland, in 1970s, different acts were formulated or constituted by the legislature. And afterwards, this process keep growing across globe. In Puttaswamy case, Supreme Court decided right to privacy as fundamental right. The impact was phenomenal. The foundation for data protection regime, I think DPDP Act was conceived once right to privacy was declared fundamental right in India. When this right was declared, I was in CBI, we were just thinking that how it will be implemented. So the implementation of right to privacy was difficult for police or any organization for that matter. But once the Data Protection Act in India 2023 got in place, then it is the tool how the Puttaswamy case will be implemented in righteous spirit. The informational privacy, bodily privacy, decisional autonomy, and so on and so forth. Although the case 1 of Puttaswamy 2017, very voluminous case, but it's very interesting. Whenever you get time, please have some paragraph to read. Actually, this judgment, Puttaswamy has overruled two important judgments of the same court. Although they were of the lower judge bench. MP Sharma, very famous case of 1954, which was of 8 judge bench, and Kharag Singh of 1964, 6 judge bench. So both these judgments were overruled as far as right to privacy is concerned. In these both judgments, it was told that right to privacy is not fundamental right. The foundation was laid by Puttaswamy for Navtej Johar case for homosexuality. Actually, this judgment was just followed after Puttaswamy. See the dates. Case Puttaswamy was declared on August 24. However, Navtej Johar was declared on 6 September. By the way, 6 September is my date of birth also, so I always remember this case with very fond memories. And another one is Joseph Saini, decriminalization of adultery. This was also in September, but it was in 2018. So almost these all things happening. You see, in 2017, Puttaswamy in India. Again, 2018, Puttaswamy 2, Aadhaar case in India. In 2018, these two important cases, Navtej as well as Joseph Saini, then GDPR. So in privacy sector, if I say 2018 is the landmark year for establishing right to privacy and data protection together. The foundation for Navtej, as I mentioned already. This is the case number 2 of Puttaswamy. This is Aadhaar case. And in this case, Supreme Court held that the constitutional validity of Aadhaar. And it acknowledged the potential for misuse of Aadhaar data and emphasized on data protection measure. That is why the Aadhaar data is not being supplied even to the government departments by UADI. So, UDAI. So, this is very important area. Then it reinforces on right to privacy as fundamental right and on data privacy. So, data privacy is the key area of Puttaswamy 2 in 2018. It impacted strengthened consent-based use of sensitive personal data. So, consent and privacy are the two sides of the same coin. Without consent, you cannot use the data. It will violate privacy. These are the basic understanding. It led to architectural shift in Aadhaar data compliance. Then this is another important case, Internet and Mobile Phone Association of India versus RBI in 2020. The Supreme Court held that it struck down RBI Circular 2018 which prohibit trading of cryptocurrency. So they say that you cannot take away or you cannot abridge the right to business. And it reaffirmed the need for evidence-based regulatory action and highlighted importance of reasonableness and due process in cyber regulation. This judgment actually established that you cannot formulate rules by your own choice. It has to be in the basic framework of the law. Then Twitter Inc. versus Union of India of 2023. The legal issue was legality of consent takedown order under IT Rules 2021. The High Court held that the social media platform must comply with takedown order by government under 79, as I mentioned. So, this judgment is important that it actually validates Section 79 for giving order by the government to the data fiduciary to take down in the specified period. The impact was that social media platforms do not have unrestricted autonomy under the freedom of speech, and it enforced the compliance burden on intermediary. You understand, in IT Act, the term is intermediary. The same identity is called data fiduciary in DPDP Act. So intermediary is equivalent to data fiduciary in DPDP Act. Then Anuradha Bhasin versus Union of India. The 2020 case, legality of internet shutdown in Jammu and Kashmir. So the Supreme Court held that freedom of speech and trade via internet, it is constitutionally protected, and internet shutdown must meet the test of legality and proportionality. It recognized the digital access as a constitutional right component and pressed for transparent review executive order. That means that the importance of this case in very nutshell is that government has the power if you want to shut down, but it cannot be arbitrary. It should be the speaking order. It should explain why this order has been taken. So it is a balancing approach. It cannot be arbitrary. That is the beauty of this judgment. Then comes in re Parajwala letter case. This Parajwala letter case of 2018, friends, was also important, where this letter was taken as suo motu writ. This Parajwala was an NGO, and matter was online sexual abuse material and safe harbor, particularly for children. The Supreme Court directed to set up hash value based filtering system, and I think after this case Parajwala, lot of websites which were porn in nature, they were taken down. It recognized digital access as a constitutional right component. It pressed for transparent and reviewable executive action in cyber space. Then Shreya Singhal, I already mentioned, in 2015, where constitutional validity of Section 66A was challenged, and finally, Honorable Supreme Court of India struck down this section as vague and chilling for free speech. Basically, in this case, two girls of age maybe 18-20, very young, they were just chatting on social media, and for some death of Baba Saheb Thackeray, Bala Saheb Thackeray was dead, and just in the memory or in the for mourn, his supporter actually declared Bandh for Mumbai for some time. And these girls they were chatting, and FIR was lodged, they were being arrested by police. Ultimately, matter went to Supreme Court, and this section 66A was found vague and was struck down by the Honorable Supreme Court. It created precedent for proportionality in cyber laws. They say that it should not be disproportionate. Disproportionate in context of the personal right and the public right. These are now the comparative study of the cases which we have discussed. So I don't want to take much of time, but K.S. Puttaswamy about privacy and data protection. So it is a linkage between privacy and data protection. Then Twitter versus Union of India, compliance with takedown order. Then Internet Association versus RBI about proportionate regulation. Then WhatsApp versus Union of India, traceability and encryption. Anuradha Bhasin about internet access in Jammu and Kashmir and all. Shreya Singhal, free speech and cyber laws. So these are very easy to remember. Now let's move to United States. We have understood various cases in Indian context. So in US, the Carpenter versus United States, 2018. As I said, 2018 is a watershed time. The legal issue before the US Supreme Court was whether accessing historical cell phone location data without a warrant violated the Fourth Amendment. The Supreme Court held that the government access to cell site location information without a warrant constituted search under the Fourth Amendment. It extended constitutional privacy protection to digital data. Then FTC versus Wyndham Worldwide Corporation in 2015, US Court of Appeal for Third Circuit. Legal issue was failure to protect customer data from repeated cybersecurity breaches. This is a big problem, the breach of cybersecurity. The court held that cybersecurity practices must be taken into account. And its significance is that it affirms FTC authority to regulate data security. So you can say it is a precondition that the court directed that the service provider must have adequate measures for data protection and cyber security. US versus Nozzle. Nozzle 1 and 2 cases, there are two different cases. The legal issue was unauthorized access under Computer Fraud and Abuse Act. The court held that Nozzle was accused of using credential of ex-employee to steal data from his former employer. Basically, this data stealing. Data stealing these days I think is very common in India and many other countries. Like say for example, you want to start a hotel business, but you have enough money, you have developed a very beautiful hotel with all facility. But how to get customer? It may take time. It may need lot of publicity and all, which is not so easy. So what generally people may do, and they are doing, there are reported cases that they generally either hire some hacker to get data, or alternatively they actually buy the employer of the established hotel and they provide the list or the data of the customer, and then the new hotel, they can approach the customers to allure them, giving them various concessions and all, and that way this data becomes very important for both parties. And this is not very theoretical thing which I am telling. This is a very, very practical, and even a small businessman, right from top to bottom, are facing this problem, how to protect their data, how to protect from hacker, how to protect from their own employees. That is why this cyber security, cyber auditing, all these things become excessively important for survival of the business per se. The significance of this case is it prevents the over-criminalization of term of use violations, and it set boundaries for employer control over employee as per getting their digital data or digital information. Facebook Inc. versus Power Ventures of 2016. The legal issue was Power Venture accessed Facebook user data through its own interface without taking permission from the users or by the Facebook. The court held that it continued access after a siege, and does it later violate the CFFA. It reinforced that consent withdrawal matters in digital access. Spokio versus Robin in 2016, the legal issue was whether a person can inaccurate data posted online under the Fair Credit Reporting Act. The court held that plaintiff must show concrete harm, not just statutory violation. So when you go for violation of your right, the cause of action must be very clear, where there should be clear-cut, violation of the right. That is what this judgment says. It defines the standard of standing in privacy cases. That means what is your locus standi in privacy cases. So everybody may say that my privacy has been violated, but there should be a baseline. So this case talks about the baseline to stand in the court of law to file the suit. And it also helps the court to assess privacy harm versus procedural violation. There may be procedural violation, but do they amount for privacy violation? So procedural violation and privacy violation, there are difference. So this case reflects upon those minor implications. Epic System Corporation versus Lewis of 2018 again. The data privacy and arbitration in employee contracts. The court held that arbitration agreement can prevent class action lawsuit for data protection. The significance of this case was limited employee ability to litigate collective privacy violations. Google versus Oracle in 2021. It was a copyright of Java API and fair use in code reuse. The court held that Google copying of Java was fair use. In this case, the legal issue was that Equifax breach exposed personal data of more than 147 million users. The court held that Equifax agreed to pay $700 million, which is a huge amount for the settlement. Victim received free credit monitoring, identified theft protection and compensation. It is one of the largest settlements in data breach case, 700 million, just imagine. So any company can well imagine to pay as compensation for data breach up to the tune of $700 million. This is again the comparative analysis. I don't want to take much time because now already we are moving ahead. United Kingdom. The case, important case is Google Inc. versus Waddell Hall. The legal issue was unauthorized tracking of iPhone user, browsing habits via Safari browser. Court held that the damage can be awarded under DP Act of 1998. It impacted the expansion of data subject rights. So the data principle in Indian context, you can say that the right of the data owner was expanded. R versus Neil. The legal issue was a nurse accessed a patient medical record without valid reason, and the court held that conviction under 55 of Data Protection Act for unlawful access. This case is very huge, important because it reinforced criminal consequence for internal data breach by staff. So breaching any data by the staff, this is a common problem, as I mentioned, that in hospitals they may be actually spying, maybe by hackers, by the internal staff, by the pharmaceuticals, but the pathological reports may be also collected. So there are so many use and misuse of these data. So data is gold mine, and hospitals and others. So business actually depend on how vast data you have, and to get those data, people are using unethical methods, even the criminal methods many times, and that is very much worrisome. Then Lloyd versus Google of 2021, the legal issue was class action under UK Data Protection Act for secretly tracking users' data. Again, the hackers and others. The UK Supreme Court, as I mentioned that earlier it was House of Lords, which was changed or converted into Supreme Court in 2009. So this is again important point to note. Many law students and others must be listening me. So UK Supreme Court denied representative action because no proof of material damage or distress. So as I mentioned that cause of action must be there. There must be some loss, there must be some injury. Otherwise, case cannot stand, and it actually clarifies that loss of control of data is not automatically compensable. So until unless there is some reasonable ground for awarding compensation, then only it can be awarded. Then comes the Information Commissioner Office versus Facebook. This is Cambridge Analytica scandal. I think this is one of the very important case which was also responsible for GDPR. Although this case was running since many years, the judgment came in 2018, and in the same year, after few months only, GDPR was enacted. But this case has a grave impact, very deep impact on formulation of GDPR. The legal issue for Facebook allowed improper access of data of millions of users, and ultimately it was misused for analyzing the voters' pattern and all. and it showcased ICO willingness to enforce against global tech. And this case is not only important for UK purpose. The same method by this same data was also abused in US as well for influencing the voters and all. Then R versus Whitehead 2010, the legal issue was employment agency owner unlawfully obtained data from NHS spine system, again National Health Scheme. The order of the court was the fine up to 50,000 this sterling under section 55 of DPA 1998. It highlights the importance of encryption, firewall and monitoring for the purpose of cybersecurity. Then Dixon Car Phone Limited. The legal issue was major breach affecting 14 million data records due to poor security. Again, the fine was imposed, and this again emphasized that misuse of official data system is punishable. Then British Airways data breach of 2020. Here again the fine was up to 20 million pound, and significance one of the largest data protection fine in UK history. So by and large what we have discussed in United States, India and UK, that these laws were formulated in somewhere in 2017 in India. Right to privacy was recognized as fundamental right. Then 2018 various other judgments came in US, UK and others. So this in last 5-7 years particularly, this data protection has come to very wide manner, and now it is the key area for cyber security. Then Marriott International 2020, the legal issue was cyber attack exposed guest data of 339 million people globally. Court fined up to the tune of 18.4 million sterling pound. It signifies due diligence in acquisition and retrospective responsibility for inherited data practice. Again, I have given a comparative account or that matrix. I will share these slides, you can go through. Now let us go to South Africa. There are certain important cases of South Africa also. C versus Department of Health of 2022. The legal issue was alleged violation of privacy right of various patients without taking their consent. Court affirmed the importance of explicit consent and data subject rights. So again, in South Africa, the data cannot be used or misused until unless there is explicit consent from the patient. My vote count NPC versus Minister of Justice. Again 2021, the legal issue was whether political parties were obliged to disclose donor identity. That donor identity, like in India and many other countries, the political parties are exempted to disclose the donors, and same was in South Africa. Here the court held that acknowledging the tension between access to information and privacy, it ordered enhanced disclosure but within bound of data protection. So it was said that there will be a kind of immunity, but it should not violate the data protection laws. Justice Alliance of South Africa versus Minister of Safety and Security. The legal issue was challenged to a legislative proposal. Political parties were obliged to disclose donor identity. Again, the same issue. H versus W, 2013. The court in this case held that award damage for violation of dignity and privacy. So, dignity and privacy in South Africa was recognized since long. and it is a case which recognized digital image misuse as actionable tort. Then global technology versus aerial concept in 2021. The legal issue was use of former employee email access. Court held that unauthorized email access could constitute interception and privacy breach. And this is again this interception of email, your personal data by law enforcement agency. This remains a very, very touchy or very sensitive domain in every country. Here again, this comparative study. Now, this is the last slide. Almost in 1 hour we could conclude our discussion. So, the overall discussion, if we conclude, my dear friends, data is the gold mine and everyone looking for data. So now, it is your responsibility, it is everybody's responsibility to secure data. It is the individual's responsibility, it is the company responsibility, or in other sense I can say in legal term, it is the duty of the data fiduciary to protect the data of the data principle. And not only in service sector, but the product sector are equally important. And now it is the time and it is the clarion call for privacy by design and legality of design. These are the two terms derived from Article 25 of GDPR of 2018. Data is power, which is base of AI research. Data protection laws are in nascent stage in various countries, although data protection laws has been formulated, but it will be tested in courtroom. So I think in settling any law, it takes time. Sometime maybe decade, maybe long time. And I think data protection laws will be tested in court of law with period of time, and then it will be providing better results in the society. No ideal protocol for implementation. Every country has its own requirement. It has its own political, cultural, social ethos, legal ethos, and so on and so forth. Cyberspace and technology are dynamic, so must be the protection laws. There is a lack of uniformity. Although data has no boundaries, but law has always boundaries. There are international laws, but they are only guidance, guiding principles. They have no enforceability or liability. So these are the real challenge. Integration of technology and legal acumen. Actually, this is what our institute UPSIFS Lucknow in India is doing. Actually, what the need of GDPR, our DPDP Act, or any act for that matter, integration of law with science, integration of legal domain with technology. And this is the focus we are doing. This term law with labs, actually I coined this term, and let me just explain that legal experts, right from the judiciary to prosecution and our defense lawyers, they must be trained in technology, maybe forensic, conventional DNA, fingerprint and all, or maybe in cyber technology. On the other hand, the technocrat, they also need the knowledge of the law. They cannot be advocate, I understand, but the basic knowledge, so that right from the beginning, when you conceive a design, when you conceive any any system or any program, right from the beginning, the legal implications must be seriously looked into. Otherwise, what we are doing today, it is patchwork. Then integration, capacity building, it is a global requirement, and let me tell you that whether we recognize or not, we all need training. We all need interdisciplinary approach, and this is the need of the hour to protect our data. And at the last but not the least, awareness is the key. Awareness of everybody, awareness of people, awareness of the policy makers, awareness of the executors, awareness of the judiciary. everybody are in the need of the awareness about how the legal framework of data protection must be executed in a more transparent and systematic manner. With this, I conclude my talk, my dear friends. Be with us, give your comment, suggest us what more I can do for improving the content, or which may be more suitable for you. You can suggest us some topics. I will be very happy. And those who can visit our institute in Lucknow, India, it is very close to Delhi, and we have various programs in our institute. You can log or you can visit our website UPSF Lucknow, and you will see the beautiful campus, the state-of-art technology, and the very innovative pedagogy what we are providing in last 2 years. We are only 2 years young, and we are conducting a very important conference for 3 days. Our Honorable CM Yogi Adityanath ji is going to inaugurate this on 18th of August, and this will be a very huge gathering of professionals